You're listening to In the Balance, an Iowa Judicial Branch podcast. Welcome back to another episode of In the Balance, Iowa's Judicial Branch podcast. Today we're talking with Justice Edward Mansfield of the Iowa Supreme Court about what inspired him to pursue becoming a judge, how he is spending his free time during COVID-19, and diving deeper into how the Supreme Court decides which cases come before their bench. Thank you, Justice Mansfield, for being with us today. Before we get started, I wanted to ask a couple of questions about you. You call yourself an Iowan by choice. Where did you grow up and how did you get to Iowa?
Well, I grew up in Lexington, Massachusetts, and I attended the Lexington Public Schools. I then went to college and law school in the Northeast. But a number of years ago, I came to Iowa because I was following my spouse who had a job offer in Des Moines.
Great. And what sparked your interest in becoming a judge after you received your degrees?
I had, right out of law school, clerked for a judge on the United States Court of Appeals for the Fifth Circuit. That's the federal appellate court that's based in New Orleans. And I greatly admired my boss, Judge Higginbotham. He's actually still a judge today. He's 81 years old. He's taken senior status, but he's still very, very active. And in the back of my mind back then, many years ago, was the thought that someday becoming a judge myself would be a great way to pay back the legal system for what it's given me and maybe to perform public service at the last stage of my legal career.
Wonderful.
So I tried several times, went through the commission process and the application process. My name was sent to the governor a few times, and eventually I was appointed to the Iowa Court of Appeals in 2009, and then I joined the Supreme Court in 2011.
Great. Apart from being a Supreme Court justice, what interests you on a regular basis? What do you do in your free time?
I teach at Drake Law School in the evenings. I'm not teaching anything this semester, but in the spring I'm planning to teach antitrust and sports law. Or actually, it's the other way around. It's sports and antitrust law. It's about 2/3 sports law. I love the give and take of dealing with students, and it's an endeavor that really keeps me young. Also, I belong to a 5 a.m. workout group. Since the pandemic started, we've been meeting outside, and we generally go on lots and lots of long walks. For example, this morning at 5 a.m. we met and we walked up the hill to McCray Park in Des Moines. It ended up being about a 5-mile walk. Last month, I was actually able to kind of build on my walking, all this long walking that I've been doing, and I got the chance to climb Mount Elbert in Colorado, which is the highest peak in Colorado. It's the hardest thing I've done in a long time. The last thing I want to mention in terms of kind of a personal interest is a COVID project that I've started on, encouraged by my daughter, who was an English major in college, is I'm reading the plays of Shakespeare. I think I've gotten through 14 of them right now. And I find it very, very rewarding. It's something I've never done. Most of the plays, if I've read them at all, I read them in high school. And it's amazing how many turns of phrase that we use today come from him. For example, sea change. We think of that as such a trendy, modern expression, and that actually comes from Shakespeare's The Tempest.
Do you have a favorite play that you've read so far?
I really, I think Richard II is really, really interesting. My daughter said, "You're really going to like this play," and she's right.
Wonderful. So today we are talking about specifically how a case gets to the Supreme Court. So how does a case that has been decided at a district level apply for and receive appeal?
Essentially, all appeals come directly to our building in Des Moines from the 99 counties throughout the state. So there are well over 1,000 appeals taken, between 1,000 and 2,000 appeals taken every year. And technically, all of those appeals initially come to the Supreme Court. It's an unusual system that we have in Iowa that I think only one other state has. It's called a deflection system. Even though all of those appeals, those between 1,000 and 2,000, technically come to our court, we only hear about 110 cases a year. Most of the cases get to our court. Those 110, most of them get to our court in one of two ways. Either we retain the case, that is, it comes to us directly and we never let go of it, or we grant further review of a Court of Appeals decision. So every year we hear about 40 to 50 retained cases and 40 to 50 further reviews.
So what do you mean by a retained case versus a further review? And how does the court decide which cases to retain?
So the retained cases are the ones that come directly from the trial court to our court. They don't go through the Court of Appeals. The Court of Appeals never sees the case and doesn't decide it. Court of Appeals decides most of the appeals in the state, but these 40 to 50 retained cases never go through them. So, the way we decide whether to retain those cases is kind of complicated, and I'll talk about that in a few minutes. But the basic principle is we retain the cases where the law is unsettled, where it's an issue of considerable public importance, essentially the kind of cases that we think are going to end up eventually in our court, even if they went first to the Court of Appeals.
Are there any rules and procedures that you guys abide by to decide what to retain?
Yeah, sure. There are some specific rules and processes. So some categories of cases, and these categories are fairly large, go automatically to the Court of Appeals. That would include, for example, child in need of assistance or China cases, parental termination cases, dissolution of marriage cases, guilty plea appeals. So there's several categories that just go automatically to the Court of Appeals. Of the remaining cases, the ones where discretion is exercised on whether they should be retained or not, the staff attorneys who work for our Supreme Court clerk review them after all the briefs are in. So parties file all their briefs. Staff attorneys on the first floor of our building look at those cases, examine them closely, and they prepare a slate of cases for what's called screening every month. And on each case where they think it's a close call, should we retain or transfer, is kind of a close issue that they want our input on, they'll have a 3-page or so memorandum prepared. The memo will have a summary of the facts of the case and the issues on appeal, and then it'll have the staff attorney's own recommendation on whether the case should be retained or transferred.
And how does that screening work, and what does it look like for the justices?
Well, we do the screening once a month. Generally, it's like the third or fourth Tuesday of the month. So as we're recording this today, the last screening we had was, I think, September 22nd, and the next screening that we're having is October 20th, I believe. The screening panels are rotating panels of 3 justices from our court. The whole court doesn't do the screening, so it's sort of a subset of the court. And those 3 justices are taken from the 6 members of the court other than the chief. So if you do the math, you'll see that each one of us on the court gets to serve on a screening panel every other month. I serve on 6 of the 12 screening panels every year. The screening panel members then review the memos that have been prepared, these 3-page memos, and kind of think about the case and talk about it at a conference, and then vote on which of the cases to retain and which of those cases for that month to transfer. And it takes 2 out of 3 votes, obviously, although most of these decisions are unanimous. If the case is retained, then the screening panel will also decide whether oral argument should be set for the case or whether it should be decided without oral argument.
What do you look at as far as whether the case should be retained?
The staff memos talk about the same criteria that are in the appellate rules. It's, I think, Rule 6.1101. So there's substantial constitutional question, substantial issue in which there's claimed to be a conflict with a published decision of the Court of Appeals, the Supreme Court, or controlling federal authority. Substantial issue of first impression, that's a pretty common category. Fundamental and urgent issue of broad public importance. Substantial question of enunciating or changing legal principles. Those are the criteria that are reviewed.
And can you give some examples of what that might look like?
Yeah, I think actually it's helpful sometimes to think of those criteria in terms of specific examples. So a common situation that arises, and a lot of our retained cases seem to be of this category, is the legislature will pass a new law, and that law's never been interpreted by the appellate courts before. Those kinds of cases are kinds that we often retain. So, for example, last term, we decided, after retaining them, 2 different appeals that presented different issues of statutory interpretation under the Stand Your Ground law. That was a law that the legislature had passed in 2017. It took several years, of course, to kind of work its way through the court system and get to us. But that would be a good example of the legislature passes a new law, and then we retain cases to decide how that law should be interpreted. Another thing that will happen is our society changes. Issues that were not important years ago become important now, and new legal issues emerge. So, for example, just this past spring, toward the end of our last term, we retained and decided a case about a city's legal responsibility for a bike path. Well, bike paths are becoming more and more common. So we thought maybe that's a legal issue that would be important. We also retained and decided a case, a landlord-tenant case, where there was an apartment building that had a no pets policy, and there was a disagreement between one tenant who had an emotional support animal and another tenant who was allergic to dogs. We felt that situation was one that we got the sense maybe emerging more and more today, and therefore that was also an appropriate case for us to retain.
For attorneys applying for appeal, is there any way that they can affect the screening of their application for appeal?
Well, the rules themselves require a routing statement to be included both in the appellant's brief and in the appellee's brief. The routing statement says whether the case should go to the Court of Appeals or whether it should be retained by the Supreme Court. And sometimes you get the appellant says, oh, this should be retained, and the appellee says, no, this should go to the Court of Appeals, and that's all they say. That in itself is not all that helpful. A routing statement that gives reasons and explanations can be very helpful. The routing statements are something that we pay attention to, and the staff attorneys in preparing those 3-page memos that I talked about definitely pay attention to. We almost never retain a case that both sides ask us to transfer, and conversely, we often retain cases that both sides ask us to retain. Kinds of things to talk about in the routing statement. For example, if you think the case should be transferred, and you're aware of some procedural issue or some error preservation issue that may prevent the court from reaching what would otherwise be a significant legal issue, you should explain that and even argue that a little bit in the routing statement. So remember that the staff attorney will be reading the routing statements and the full briefing and writing up a short memo with a recommendation for us. So we're kind of getting the staff attorney's condensation and summary and analysis. So to some extent, your immediate audience is the staff attorney. Those people are very good at their job. They've been working for us for a long time, and they're pretty sophisticated. So you should write the routing statement as if you're writing it for a seasoned court watcher.
Great. You mentioned earlier that you initially retained 40 to 50 appeals. How do you decide on appeals that you take on what you called further review?
So as I mentioned, the vast majority of cases go to the Court of Appeals. The Court of Appeals, I think last year, decided 1,300 cases. But anyhow, once the Court of Appeals decides an appeal, if a party isn't happy with the result, they can then ask us to take further review. And to do that, they have to file within a very short period of time a further review application. The further review applications are sort of analogous to a petition for certiorari to the U.S. Supreme Court in the federal system. So what the application does is ask us to exercise our discretion to take that case and review the decision of the Court of Appeals. We get about 500 applications for further review every year. And as I mentioned, we grant further review in about 40 to 50 cases. So less than 10%, somewhere around 10% or even less, further review is granted. Most of the time, further review is denied. So let me talk a little bit about how that works when we get the further review applications. So every justice on the court, all 7 of us are involved in that, and each of us will read every application for further review that's filed. So again, every year we're reading somewhere around 500 applications for further review. Every Court of Appeals decision in every one of those cases, and any resistance to the application for further review, and then also anything else in the briefing or in the record that we want to look at that point in time. So we do this reading, and then there's a voting sheet, and the voting sheet has a space for each of the 7 of us. And after you've read your set of further reviews, you vote on them and record your votes. And so what you typically do is you will vote either Y or N. So Y means I favor further review of this case, or at least I'd like to talk to my colleagues about the case or look into the case further. I think it may warrant further review. N means I've looked at all the papers. I'm not interested in taking further review of the case. So all 7 of us will record those votes on the voting sheet. If we vote Y, often we'll put a comment there, and there'll be kind of strings of comments. One justice responding to another justice, responding to another justice. But if a case gets all N's, then it doesn't go to conference. Further review is automatically denied at that point.
You mentioned that you read all of the materials for the further review applications, and that for the retained cases, you have staff attorneys that help you summarize and condense information. Do you have any staff involved with further reviews?
On that side, generally not. We aren't the U.S. Supreme Court, which has 4 law clerks per justice, and then therefore they set up a cert pool, and there are memos done by the law clerks, as I understand it, on every cert application. Each of us has only one law clerk. I'm smiling at mine right now as we record this. And they're often busy researching and helping write our opinions. So our court is pretty lean, actually, compared to most states. Most states, the Supreme Court has 2 or 3 law clerks per justice. So we really handle the further reviews on our own. To give you a little more background on how it works, so every 2 weeks, because the Court of Appeals releases opinions every 2 weeks, then after that, there'll be a batch of further review applications that comes in. So let's say the Court of Appeals releases 40 opinions on a Wednesday, then usually about 6 weeks later, there'll be a batch of maybe half of those cases where the parties are seeking further review. So there'll be, say, 20 further review applications. And that becomes kind of weekend and evening reading work for the individual justices. For example, right now, as we're recording this, we have a Friday deadline coming up to vote on a current batch of further reviews. It's a relatively small batch of only 13 further review applications, but it's several days away, and I have to admit I have not gone through them yet. So I'm kind of running out of evenings. I'm going to have to set aside some evening time to make sure that I get through them.
What would you tell an attorney to keep in mind while writing an application for further review?
Along the lines I've been talking about, I would assume that each justice is reading your application on an evening or weekend, along with approximately 19 other applications for further review. So you do kind of need to stick out. You don't want to just be rehashing your original brief. And the rules kind of encourage you to do something in that regard. Rule 6.1103 requires a statement supporting further review at the beginning of the application. And that's kind of the most important part of the application. It's where you want to get the reader's attention. You must provide, and here I'll quote from the rule, a direct and concise statement of the reasons why the case warrants further review. Typically, in the better further review applications, this statement of reasons is, a page or two long. You should explain in the statement succinctly what's wrong with the Court of Appeals decision and why we need to intervene, why the Court of Appeals decision is both incorrect but also will have negative consequences in the future. You want to put the Court of Appeals decision in broader context, criticize it, but obviously criticize it respectfully.
Can you elaborate on what you mean by the broader context?
Remember that you're at this point, you're not just arguing your appeal, you're arguing why we should make this one of our 40 to 50 further review applications that we grant every year. And so the focus really should be, in large part, on the Court of Appeals decision. Certainly, we're aware that even unpublished Court of Appeals decisions get cited and relied upon by the district court. So I think what you want to talk about is why that Court of Appeals decision may create problems in the future, as I've mentioned.
Are there any points an attorney resisting an application for further review should make in their writing?
Well, it's kind of the flip side. You want to argue two things if possible. One, Court of Appeals decision is correct. And secondly, really there's nothing special about it. The case doesn't raise any unique or important issue. It's just part of the run-of-mill of Iowa case law. Even if the decision were wrong, it would be a decision based on specific facts of the case, and it doesn't have broader applicability. So hopefully you're able to argue both of those things, because that would be the better situation if you can. One other thing that comes up sometimes is that the law may have changed. So if we take further review to correct a legal error or to interpret a law that maybe the Court of Appeals interpreted in a different way than we would have interpreted, our decision won't have lasting impact because the legislature has already gone ahead and changed the law. So if that's the case and you're resisting further review, be sure to point that out.
So you say there's at least one Y vote and the case goes to further review conference. What does that conferencing look like?
Those conferences can be fairly short or they can get fairly long, depending generally on how many cases we have to talk about. All 7 justices will discuss the case and debate whether to grant further review. Sometimes the case will be held over to the next conference, say in the next month. So one of the justices can be kind of delegated to study the issues some more. And that's where the law clerks may get involved a little bit. That justice's law clerk may be helping that justice with that deep dive. In any event, at the conference, it takes 4 votes to grant further review. Otherwise, review is denied. And if we grant further review, we'll also vote on whether to grant oral argument or to submit the case non-orally. Same decision that we make in the screening panels as well.
You said that most of the cases the Supreme Court hears are either retained or further review cases, but are there other cases outside of those realms that you hear as well?
We also hear about 15 attorney disciplinary cases a year. That's how we get the numbers up a little bit higher than the 40 to 50 plus 40 to 50. The disciplinary cases arise when an attorney is charged with a significant violation of the rules of professional conduct, and a grievance commission finds that a sanction should be imposed. When those things happen, then we review those cases. They come up during the course of the year directly from the commission. They don't go through another court. They all come to us. We review the facts, the law, whether there was a violation. We also review the sanction. And then each of those cases will involve a complete opinion, which is released along with all of our other opinions for that particular term. So 15 cases, that means for planning purposes as a justice on the court, I typically assume I'll have to write about 2 disciplinary cases every term.
Are there any other unique cases that come before the court each year?
Well, we operate in a federal system, and that means there are state courts and federal courts, of course. That means the state courts ourselves sometimes have to decide issues of federal law that come up in our cases, and the federal courts have to decide issues of state law that come up in their cases. When a federal court in Iowa is uncertain about an issue of Iowa law in a pending case, what the law is, they have the ability to certify that question to our court. And what happens is we then decide that question, that piece of that federal case, and then we send our answer to that question back to the federal court, and the federal court runs with that answer and continues with the case. Now, those are not a major part of our caseload. Typically, we only get 1 or 2 of these certification cases a year from the federal court system. We did have, in September, one of the cases that we heard was a certified question case.
Great. And my last question for you is, if you could leave the listeners today with a message about the Iowa court system, what would it be?
This is your court system. The way I put it is I like to tell people, I don't represent you like a legislator. I am not to decide cases, and I don't decide cases based on public opinion or my personal views. That would be contrary to my oath and to my job. But I do work for you. And if you have a suggestion on how we can improve court processes, court rules, court procedures in this state, please let us know, especially in this time of COVID. And feel free to contact me personally with any of those suggestions.
Great. Thank you so much for taking the time today, Justice Mansfield.
Thank you.
You've been listening to In the Balance, an Iowa Judicial Branch podcast hosted and produced by me, Marissa Gaal. If you would like more information about Iowa's courts, you can visit www.iowacourts.gov. You can also follow the Iowa Judicial Branch on Twitter and YouTube at Iowa Courts. This episode of In the Balance is now adjourned. Until next time.